I'd like to thank you to begin for coming back promptly so that we can commence our afternoon program. We will leave a question period available for the end. The panel that we're about to embark upon deals with some of the more recent breathalyzer approved instruments, approved screening device instruments that are referred to in the code and that we've been able to bring here, and we'll hopefully be able to provide an explanation as to how these machines and instruments work. It may well sound like Star Trek, the next generation, when we're done, but I can assure you that the people who are present on the panel are very able to explain that to you. Toward my far left is Jim Wigmore at the Center of Forensic Science in the Toxicology Department. Next to him and to my immediate left is Doug Lucas, who is the very distinguished director of the center and has been for over 27 years now. To my immediate right is Steve Price, who writes a column known as Slurred Speech in the Criminal Lawyer's Newsletter and likes to be referred to as the Slurred Speaker. And to his my far right, rather, is Jerry Kupferschmidt, who also has considerable expertise in toxicology. And to my great relief, I only get to ask the questions and not try to answer them. In the material in the final tab, there is a paper dealing with criminal code approved instruments that will hopefully provide you with some reference material. And although I've written the paper, I'd like very much to acknowledge the help I've had from Doug Lucas and also Catherine Kane, who's present today, who came down from Ottawa. We're going to refer to the work that she does in dealing with instruments that are recommended for approval status. So with that, I'd like to begin turning to Doug. Doug, there's been reference earlier today primarily to the alert model J3A screening device and the alcohol test committee and whether this is really an approved screening device. I'm not sure that a whole lot of people, especially including myself, understand how an instrument winds up being called an approved instrument or here an approved screening device. I wonder if you could provide us with an explanation as to how the scientists get together and decide whether or not something that is submitted winds up being an approved screening device or approved instrument.
Okay, there are two things really involved in the approval process. Bulk of the work is the technical evaluation of the device, but then there are the legal requirements that have to be met that Catherine has to deal with. And I suspect that for Catherine, that while this is not the job that takes up most of her time, it may be the source of her greatest frustrations dealing with the various manufacturers. In order to be approved, either a screening device or an instrument, an evidential instrument, manufacturer, first of all, must come to the Department of Justice and say they have this device and they would like to have it approved. And I can tell you that while there are not a lot of devices approved for use in Canada or being used in Canada, manufacturers like to have devices approved in Canada because it's probably harder to get them approved here than it is in many other jurisdictions, certainly than it is in the United States. And so it to them is of some value to have, even though it's not sold in Canada, to have a device that has been approved for use in Canada. One of the reasons for that, that it's more difficult to become approved in Canada is that the standards require that in addition to all of the other tests and tests of linearity and specificity and so on, there must be human subject tests. And in other jurisdictions, those aren't required. And the reason for that is that those of us involved in the technical side believe that that has to be the bottom line for a device intended to be used to test human beings, is that at some point you should be able to prove that it will do what it's supposed to do. So the manufacturer comes to Justice. Department of Justice then refers them to the Alcohol Test Committee of the Canadian Society of Forensic Sciences. This is a committee that's been around since 1967, when the first brooding around of so-called breathalyzer laws in Parliament started in the mid to late 60s. the Canadian Society recognized that within it there was a lot of technical expertise and that this would be required and that the government would require this in the process, and so this committee was formed and in fact was eventually adopted by the Department of Justice as its principal technical and scientific advisor on aspects of breath testing. So the device is referred to this committee, and the committee then provides the manufacturer with the specifications that the device or the instrument must meet. These are published, they're amended periodically, and they are published with amendments in the Journal of the Canadian Society of Forensic Sciences. The manufacturer then decides whether or not they believe their device will be able to meet these standards, and if they believe they can, then they're required to submit 2 production models to various members of the committee, and each is evaluated in 2 separate laboratories. So there are 2 separate evaluations, and these can take some time. During the evaluation process, quite often there are little wrinkles come up that require either clarification or modification by the manufacturer, and the process can take anywhere from 6 to 18 months. The people who actually do the evaluations, the members of the committee, are volunteers who do it as over and above their normal functions, which are primarily in forensic science laboratories across the country. If the device then meets all of these standards, then it's discussed by the committee at one of its semi-annual meetings, and it's recommended to Justice for approval. And then it goes into the legal side. The minister eventually signs an approval order, and that's published, and the device then is available and suitable for use in Canada.
Thank you, Doug. As I understand it, that would be the process to be followed for either an approved screening device or an approved instrument. There's really no difference in either case, Doug?
The standards are different, but the process is the same.
Now, we've heard reference by almost every panel today to the recall of the Alert Model J3A, which is an approved screening device and was approved in the process that we've talked about. Doug, I understand that when you're wearing your scientist's hat and you hear about lawyers talking about scientific developments, a look of horror comes to you. What, though, can you tell us from the scientific point of view, and wearing your hat led to the recommended recall of the Alert Model J3A?
Well, one of the things when you're dealing with technology is that it's changing all of the time, and there are improvements all of the time, and certainly one doesn't want to fix in cement a device as it exists right today and ignore all the possible improvements that can occur along the way. And so the Department of Justice and the committee require that once an instrument or device is approved for use in Canada, the manufacturer then is supposed to notify the Department of Justice of any changes they want to make in that device before, in fact, they're made, so that the committee and the department can decide whether or not this is a substantive change. And there's a lot of room for judgment in that between the manufacturer and the committee as to what constitutes a substantive change. Clearly, if all somebody wants to do is change the color of the case, that's really not going to affect the results of the device, and that would not be a substantive change. And on the other hand, if somebody totally redesigns the device, that clearly is substantive and would require evaluation. But there are a lot of in-between there where there's judgments. And this is essentially what happened with the Alert. In 1990, in February of 1990, the manufacturer of the Alert wrote to Justice and said they wanted to make some changes in the electronics of the device in the circuit board. And Justice referred that to the committee, and the committee looked at it and asked. There was some back and forth about what these all were, but essentially I think it's fair to say the committee didn't really feel too concerned about this because they were electronic changes. They weren't anything really fundamental to the device as such. And eventually in August of 1990, it was decided that at least with these changes, there should be a partial evaluation done. It wouldn't be one of the full school thing, but we just wanted to be able to satisfy ourselves that this was not a substantive change. And so the manufacturer was asked to provide devices with this change for evaluation. And again, there was some negotiating, went back and forth. There was some disagreement between the committee and the manufacturer whether or not this was necessary. But I guess eventually, if they wanted to sell it in Canada, we had the clout in that they had to do it. And so eventually in August of '91, they submitted two devices to two separate laboratories for evaluation. This went on, and generally there was no great concern. As I say, we weren't too concerned about these things, except that one of the devices in one of the laboratories didn't seem to function as well as it had before the modifications were made. And so again, there were negotiations back and forth with the manufacturer, and the manufacturer eventually in March of '92 said, well, there's a problem with this particular instrument. We fixed it now and we're okay. And so again, the evaluation went on, and there had been no intention to do human subject testing. We didn't think it was necessary, but it's an example of where one of the laboratories, the fellow had some human subjects that were available for another test, and he decided to do some human subject tests on this modified device, and it didn't work very well. And that started to now become of some concern. So there was more discussion and went on with the manufacturer, and finally in May of '92, quite serendipitously, one of the evaluators happened to notice there seemed to be a change inside the so-called grommet. The grommet doesn't look very impressive and isn't considered to be terribly significant, I suppose, except now we're talking about the sampling mechanism and the sampling device, the way the sample gets in. And any analytical chemist will start to be concerned if you start doing something with the sample, because no matter what else you've got downstream in the analysis, if you start out with not a good sample, you're not going to end up with a very good result. And so there was again some more discussion with the manufacturer, and the manufacturer eventually in August of '92 agreed with the committee that there had been this change made. It had been made for what the manufacturer felt were good operational reasons. There had not been apparently a sufficient testing done on it, and the manufacturer agreed that variable results. Now, the vast majority of these results were on the low side, not a big difference, but just enough to be a little bit of concern. And so in August of '92, the Alcohol Test Committee recommended to the Minister of Justice that the devices should be recalled and have this change in the sampling grommet repaired, or the insert removed. And that was done. And we felt that really was probably resolved the problem. In Alberta, however, they removed all of the units from service, and eventually they were all examined in the forensic laboratory there, and they found some additional changes that hadn't been seen before, and they started doing more and more human subject tests. And again, most of these tests tended to be on the low side, but in March of this year, they came forward and showed a few tests which were significantly high, and that then really started to bother us considerably. We had a meeting in March of '93 and decided that on the basis of this fact, we just could no longer have confidence in the device, and made the recommendation to the Minister of Justice to that effect. And subsequently, in April of '93, the units were all withdrawn from service in all of the provinces with the exception of Quebec. One of the difficulties was that the manufacturer had stopped making the device in 1991. And although we had asked for 2 of these totally new units that with all these changes in it for evaluation, the manufacturer has not been able to provide them because they've stopped making them. And so that's how the alert came to be withdrawn from service.
Jerry, from your perspective and being familiar with the alert model J3A as well, is there any moral of the story that perhaps you can offer from the manufacturer's point of view?
Well, I think if we look at the basic reasons for the alert J3A recall, we have to look at the reasons for that. And first of all, we were dealing with additions, modifications, and substitution of materials on the device. Some of the concerns related to quality control issues, and some of the other concerns related to cosmetic and non-functional type issues like colors of lamps and things like that. The issues that come out of this whole area, as far as I'm concerned, deal with basically what constitutes a change when you're looking at the manufacture of devices. Is change really only hardware? Is it only a grommet? Is it a bead? Or is it software? Is there also a software difficulty here? And most of the devices that will be coming on board in the future will have a tremendous amount of software on board, including the devices that will be demonstrated today. I think it raises the issues, must the devices be reevaluated periodically? Should they be reevaluated on a regular basis? How is that done? Should there be a policy? Should there be a repair policy? I think in terms of the alerts, I think it's very clear that many of them were never ever serviced, were ever sent for service. Should some of these devices be archived? Should the Alcohol Test Committee, for example, have some of these devices that were originally approved and maintain those for comparison? Should there be periodic checks of current production runs? I think these may become very important legal issues of the future. They're certainly scientific based, but I think that they may be concerns that they may cross your minds at some point with respect to these devices. We must realize that on one hand we have a set of specifications that a manufacturer must comply with. On the other hand, we have government agencies that design these specifications. And if there's no input or communication in those specifications from all sectors involved, then I think you run into these kinds of difficulties. And I think perhaps the alert issue is basically an issue of communication between manufacturer and the government agencies that may be involved in approving these devices. I think that the Alcohol Test Committee as it stands now is going to have a monumental task in the future with respect to breath testing and maintaining control of breath testing in Canada. I think it's going to have difficulty with respect to the approval of devices, because there are many, many devices that are equally capable of providing the kinds of results that the courts would be looking for. So you could have a proliferation of devices which may be difficult to support from a scientific point of view, because there'll be several programs or several devices that must be monitored on a regular basis. So I think that although the alert here is perhaps the tip of the iceberg, I think that, as someone said earlier this morning, that we have to keep a very close eye on technology, that we can't just accept technology for what people say it is, that there are flaws, and I think that that is the big task of those involved in breath testing in the future.
Thanks, Jerry. It has been indicated by earlier panels today that it's really too early to know how the courts are going to consistently deal with the approved screening device model J3A, which has been recalled, and I believe only one or two of them have filtered into our office, so it's not as if we have a day yet in the Court of Appeal to try to clarify the issue. Steve, you have a good sense, though, of the unreported cases that are coming in from both the provincial division and general division. What's your assessment as to the trend of authority and what the courts seem to be looking for?
Well, the leading case is Speller, a decision of Judge Lampkin, September 3rd, 1993. I'm advised that Speller is on appeal to the General Division. In Speller, His Honor had the advantage, or defense counsel had the advantage, of a concession made by the Crown in Newmarket, that the Crown, there was some issue as to what the concession was afterwards, but the concession was either that the Crown conceded that it wasn't an approved instrument, or the Crown conceded that they couldn't prove that it was an approved instrument. In any event, Judge Lampkin, on reviewing with that concession and also with an agreement that a number of the documents that have been referred to earlier in regard to the communications between the police and the Center of Forensic Science, and a number of documents indicating that there was concern with the machine, they were filed on consent. And based on those documents, Judge Lampkin went on to find that the machine was an illegal instrument because it was no longer approved, and went on to find that based on Section 8, though he considered both 7, 9, and 10B as well, based on Section 8, he found that it was an illegal search, found that the prior authorization that's required was not there, referring to Hunter and Southam. In fact, made an analogy to a case where a police officer went to a justice of the peace who really didn't have any authority to grant a warrant, and unbeknownst to him, got the approval for a search on that basis. His Honor then went on to find that based on 24-2, the evidence should be excluded. Speller has been considered by a number of other judges and just adopted completely. The problem you may find, and I don't think there's going to be a lot of these cases still to be argued, because the machine is off the road and it's not being used. It may be coming up in appeals. You may be looking to, on summary conviction appeals, to make application for fresh evidence to bring up the problem. There's still cases in some of the jurisdictions that have long time till trial dates. But one of the problems you're going to have to do is find out what the Crown's position will be on your establishing that there is indeed a problem with the machine. It can be done on consent. It can be done by way of affidavit. You may have to call evidence and bring somebody who is aware of the problem. Mr. Wigmore has been getting some subpoenas as of late, and to show that there is the difficulty with the machine. One court has taken judicial notice of the problem, and that's a decision by His Honor Judge Scullion. And Judge Scullion has taken judicial notice of the fact that there's the problem, and a number of other courts have done that. There's a very good review of all the, rather than me going through all the different judgments, there's a very good review in the last issue, I believe, of the Law Times, in which all the unreported decisions are considered. The matter has reached general division in 3 cases that I'm aware of. One is Kaczmarek, which is a decision where there was an application made for fresh evidence. Kaczmarek is on reserve right now before Judge Hayes, and Kaczmarek is a very good judgment, or a good case to get a hold of because of the material filed on Kaczmarek. There's an affidavit by Mr. Wigmore and an affidavit by Jeff Patrick, who looks after the alerts for Toronto, and there's cross-examination on both affidavits, and sets out the evidentiary basis that you would need on making such an application. There's 2 other judgments that have considered the issue in general division. One is Marshall, a decision of Mr. Justice Howden on August 27th, 93. Unfortunately, or fortunately, the issue is not decided in Marshall because he finds that there were other reasonable and probable grounds for the demand and doesn't have to deal with the issue of the improper alert machine. Similarly, in a case called Rose, which is a decision of Mr. Justice Perdue, July 22nd, 93, the issue was never argued in the provincial court. It was a case that simply relied on CASA, and the court makes the point that there was no suggestion whatsoever that there's any problem with the machine, and relying on CASA, which was earlier discussed, simply doesn't deal with the issue and finds that there were reasonable and probable grounds. The provincial court has pretty well split fairly evenly, though after Speller, a lot more of the courts seem to be following Judge Lampkin. It's a very long and well-reasoned judgment. Though he doesn't, I think that there might be a stronger argument made in regard to the 10B issue as well, in that if you find that the machine is not an approved instrument or it's not a proper instrument, the demand is then not a lawful demand, and you don't have the justification that you get from Thompson and Grant.
Thanks, Steve. If you take a look at page 2 of the paper, you'll see the 4 approved screening devices, which are currently the subject matter of the approval order and remain as approved screening devices pursuant to section 254(1) of the code. The 4th one is called the Alcates 7410 PA3, It was added to the approval list in May of 1993. Jim, if we can turn to you and have you explain what this new device means, and I understand we're also going to see your Sega and Nintendo skills in getting it to operate.
Okay, I may come out front a bit because I have the demonstration to do. This is the Draeger, which is the name of the manufacturer, German manufacturer, Draeger, Alcates 7410 PA3. The older device, if you wanted to see it, is the Alert. Okay, that's the device that's now no longer in use and have been withdrawn use across Canada, except for Quebec so far. The main difference is that that's about 20 years of technology change from this device to this device. This device and all other current roadside screening devices are all fuel cells. And this device, back in 78, 79, used a semiconductor detector. And the semiconductor detectors have problems with stability and have problems with reacting to oxygen and carbon dioxide in a person's breath. So it's, at the time in 79, it was a state of the art and it was okay for its work, but it's just been surpassed now by all fuel cells. So all the other devices now on the road use a fuel cell as opposed to a semiconductor detector. The device in use in Metro will be basically plugged in a lot of OPP places, will be plugged into the cigarette lighter in the car. Okay, so this is simulated. I'm plugging it into the supply here, but it simulates a cigarette lighter. Okay, so it'll be plugged into the cigarette lighter, and all you do, it's very easy to operate, which is one of the reasons why the device is very easy to use. You just press the side button to turn it on. You'll see the number, the model type PA3 come on. You illuminate for a period of time. Now the device has the on switch is ready to go, and it's ready to, when it's basically heating up the fuel cell, getting everything down to zero. Basically what a fuel cell does is it converts alcohol in the breath into electrons. It oxidizes the alcohol, converts electrons. The more alcohol in the breath, the more current will be generated, and you can get your different results. The calibration of the Alcates 7410 PA3 is the same as for the Alert, a simulator solution to use, and it's calibrated to fail at 100 and above. The warn or the Alert is from 50 to 99 milligrams in 100 milliliters of blood, and the pass is 49 and below. So the levels are still the same no matter what device you use. They still are all calibrated in Ontario to warn at 100 and above, and to have, to fail at 100 and above, and to warn at 50 to 99. You heard that little tone. When the instrument is all ready to do the testing, the little tone comes on and the ready light comes on. And I'll test myself for now, if you want to see what type of lunch we had at Osgood Hall here. Okay, the mouthpieces used will be spit trap mouthpieces, which will just be sealed and from different manufacturers, and you just blow into it. When I blow with enough pressure, you'll hear a tone come on, and after approximately, depending on how hard I blow, it may be 5 to 10 seconds. This device adjusts for how hard you blow. If you blow hard, it'll only require 5 seconds for the sample to be taken. If you blow soft, it'll require longer. So I'll just do my testing. The tone goes off when the sample has been accepted, and you see if it's on the camera, that little P comes on, meaning a pass. So my blood alcohol is from 0 to 49. Now to make things more interesting, we have a volunteer subject that Steve got for us, and here he is here. He's actually done some drinking. Yeah, if you want to get up here. Yeah, I think, what's the best way? How about you get there, over this way? Yeah, just don't get too near the edge. That's a failure if you trip over the end. Okay, there's the device. It's all ready to go. While we were waiting, the light came on. And we'll just get you to take a nice sample, and we'll see what you blow. So how many beers did you have? 3. That's what they all say. It's 8 or 9, isn't it? Okay, now if you take a deep breath and blow hard. Keep blowing, keep blowing, keep blowing, keep blowing, keep blowing, keep blowing, keep blowing. Okay, fine. Now, if there's a positive alcohol level, it requires a bit of time for the instrument to measure the electrical current. For a negative alcohol level, as you can see with me, for a pass, it required only a few seconds. For a positive, it requires a bit longer. And actually, what he has is a pass also. So he's from 0 to 49.
Makes you wonder, eh?
So that would be equivalent. That's consistent with 3 beers. Like I told Steve to make sure he had about 5 or 6, but he could only do 3 in that period of time. So this is a pass. So you're free to go, no problem. And we'll get him back up for the Intoxilizer 5000, which I'll show later on. So this is the device. It also may be used. See, basically, this is the measuring unit right here with the microprocessor and the fuel cell. This device plugs into the cigarette lighter, but you also may have just regular batteries or rechargeable batteries. Again, in Metro and most of the OPP places, they'll be using it into the cars because it provides nice power. You don't have to worry about batteries, and you have better conditions. So it's the latest device, the most up-to-date technology, heated fuel cell with a microprocessor. And the microprocessor will give different error messages if there's problems with the instrument. The sensor has problems or things like that, whereas the older devices do not have roadside microprocessors. This also, if the person does not provide enough pressure in that, an error message will come on saying E0, which means you have to blow a sample again. The flow required for this is 6 liters per minute. Okay, if a person can't provide 6 liters per minute, then you cannot activate the device. You have to realize that the peak expiratory flow rate for an average healthy individual is 600 liters per minute. So at 6 liters per minute, we're really at a very, very low level. Basically, what you will find people who have trouble with the device are people with a small lung capacity, and they tend to be short, elderly females. So if you have a short, elderly female, 65, 70, who's very short, they may have some difficulty, some trouble providing samples into this device or that. But I know my use of cases, I think your experience of cases too, Steve, most of the people who have trouble are these guys who are 6'3", 200 pounds. I mean, their lung capacity should be like 10 liters and should be able to blow the device off the table. But they seem to be the ones having the problems, whereas you have the short, elderly female, and they'll blow their lungs out to get a sample proper. So that's about it. This is the screening device.
65 is not elderly.
Funny on that bill we have, put down for 7 beers. Look at that. Well, this all sounds pretty impressive, Jerry and Steve. What do you do now when a client or Steve calls Jerry up and you've just found out that unfortunately it wasn't a sample of breath into the Libman J3, but this new approved screening device that looks pretty impressive. Jerry and Steve?
Well, basically, Jim has indicated to you the parameters of operation of the device, and I would agree with him that it is probably the most advanced technology with respect to roadside screening devices. However, I will just contradict myself for a second and say it is in fact old technology because the fuel cell has been around for a long time. What is new about it is software. It's all software controlled, and we have all of these transparent features now on the device that are computer controlled, microprocessor controlled. And if I go back to look at the approved instruments that are actually in this list that Rick Libman has put together, you'll see you have 3 devices other than the alert, and they're all fuel cell based, or they're all electrochemical sensors. And if I go back to look at the 3 of them in context, you will see certain features that reinforce what I'm saying. In the Alcosure, you have a fuel cell technology, you have a spring-loaded sampling device, and you have a whistle mounted on the outside of the case. So the indication that a proper sample is provided is given by the auditory signal from the whistle, and the operator decides when the sample is adequate. There's no pressure measurement, there's no timing circuit, and it draws approximately 1 milliliter of breath, and expiratory breath. And through amplification and electronic circuitry, you get a pass, warn, fail indication on the device. Now, if we go to the Alkyl Meter Sl2, it has a fuel cell, It has a minimum pressure switch of 3 inches of water, and all that basically says it's like blowing through a 3-inch straw into 3 inches of water. Is a timing circuit of approximately 3 seconds. So when the individual provides a sample here, they must provide a sample at a minimum pressure of 3 inches and for a minimum of 3 seconds. There are 2 lamps that indicate pressure and the time. The operator now decides, have both lamps illuminated? If they have, he or she may decide to allow the subject to continue blowing so that they keep getting better and better breath sample. There again, they decide to take the sample. On the Alcatest 7410, you have the fuel cell. In this case, you have a heated fuel cell. There's a pressure sensor, and it's continuously monitored by the computer. You have a conversion of airflow so that, as Jim says, there's a minimum airflow required of 6 liters per minute. So there's a computer calculating all of this as the sample is provided by looking at the pressure versus time. If that's not accomplished, then you have an error indication. The total volume, as Jim says, has to be 1.2 liters, and that is activated, or the actual sampling is then activated by the microprocessor. The microprocessor says we now have 1.2 liters of air. I will now take a sample. The difficulty I see with the Alcatest is that I think that we will see more refusals, more refusal charges, because no matter how you look at it, it's a more complicated device in terms of sampling. With the alerts and with the the Alcosure and the Alkyl Meter Sl2, the operator makes the ultimate decision as to when the end expiratory breath sample is available. Here we have a microprocessor that decides that. They can't look at the individual and say, well, they're really pushing the limit or whatever. So I see that there may be more refusal charges with respect to the Alcatest. The operators, the problem with software in any kind of measuring device, and I've seen this in a forensic lab, when as long as the equipment remains simple, for example, we all have to be very interactive with the equipment. As soon as it gets loaded up with software, we tend to take things for granted. We tend to sometimes forget about the essential operating features. And that I see as the negative with respect to this device, albeit I'm not trying to suggest that it is not a worthwhile device, or in fact that it's an accurate device. But I think it will cause some difficulty, at least in the first instance, because even the police officer now, before he could count for 5 seconds because he knew the alert took 5 seconds. Now he can't, because it may take anywhere from 4 to 12 seconds, depending on the lung capacity of the individual. That's what I see as the basic difficulty with the device.
Thanks, Jerry. Okay, Steve, so you've got a phone call from Shelley Altman saying, what do we do now?
Assuming the phone call's about a refuse, because that's where we are right now, I think the same defenses are going to still be there. We're going to see, perhaps, as Jerry says, perhaps more fails, and the client's going to be coming to you and saying that he was blowing as hard as he could. And I know I'm not a 65-year-old female who's short, and it took me about 3 times. I got 3 EOs over there before Jim was able to explain it to me to do it properly, and I then got a pass. So depending on the patience of the officer, it may very well be that you're going to see refuse cases, and the question will be defending them as you did in the past. An issue would be, what about, can I have another chance? And of course, there's case law that says you should be permitted the other chance. One issue that might come out of the alerts in regard to the roadsides now is the person who has been reading the paper and hearing that the machines are no good and that they've been taken off the road, and is not sophisticated to know that it's the alert J3A as opposed to the Alcatest that's been taken off the road. There were similar issues before the court earlier, when there was some question as to the constitutionality of the breathalyzer as a result of a decision by His Honor Judge Charles, and our Court of Appeal wasn't too sympathetic to persons who had read in the paper that the breathalyzer scheme is not constitutional, found it just to be a mistake of law, and in a case called McIntyre and a case called Stady had no difficulty in upholding convictions.
Thanks. We're going to move now into the approved instrument side of things. Doug, can you give us an update about what has been going on from the Alcohol Tests Committee? I understand you had a nice conference in BC and you sailed your boat to Niagara on the lake the last time. What has the committee been adding to the list on the approved instrument side?
Well, we had to do sales, and well, there are a couple of instruments that have been approved in recent times, probably that you aren't familiar with, and there's not a lot of value in you getting familiar with because I don't think they're ever likely to be used in Ontario, at least. There still are the various breathalyzers approved, and they are going to continue to be used in Ontario for some considerable time to come, simply because in today's situation, to replace them is a very large investment, and they're providing good service, and in particularly in the vast majority of locations in Ontario where they're only used once or twice a week, it still is a pretty good device to be used. There is a device on the approval list, the Intoximeter Mark IV, that was approved in 1978. It's different than both the Intoxilizer and the breathalyzer in that it's a gas chromatograph. Was used very, very little in Canada. There were a couple used in Montreal and one used in a mobile unit in the Maritimes, but other than that, I don't think you will likely ever see an Intoximeter Mark IV. Similarly, there's a device on the list called an Alkyl meter AED1. Produced in Wales. It was in fact a fuel cell detector device, and quite a good unit, but it just never caught on as a device and has never been used for law enforcement in Ontario, although it has been used in other operations for industrial use and so on. The Intoxilizer 4011 AS was approved in 1982. It was the first of the infrared devices that was approved. Very good piece of equipment. It represented a significant step forward in technology. It was, you may be interested in, it was the device that replaced the breathalyzer in the state of California. And the reason for the replacement was not because of any great dissatisfaction with the breathalyzer, but because they had a California Supreme Court decision in a case called Hitch, which said that the police had to retain the used ampule forever and ever, and that just was logistically impossible, so they stopped using breathalyzers and went to the Intoxilizer 4011 AS. An infrared device, but not microprocessor controlled, and not likely to ever be seen again because it has been surpassed by advancing technology. There's another device, the Alcates 7110, which is an infrared device produced by Draeger, the same company that produced the screening device. It met all the standards, but really wasn't all that good a device, and I don't think you'll ever see it in use in Canada. That brings us to the Intoxilizer 5000C that was approved in 1992. Very significant advance over the 4011 AS and over some of the others, and Jim's going to describe it in just a moment. And finally, earlier this year, the breathalyzer Model 900B was approved. This is an interesting device, and it takes the basic time-proven technology of the breathalyzer and makes it controlled by a small processor with a printer, so that you get an automatic printout of the device. Other than that, it's basically the same as the breathalyzer. Unfortunately, its time has passed the breathalyzer by, I think, and I don't think we're likely to ever see the 900B in use in Canada, even though it is quite a good device. In fact, the manufacturer has indicated they're not even going to make any until they get an order for 50, and they're not likely to get that. So I think essentially what you're likely to see for some time still in Ontario and most of Canada is the breathalyzer and the Intoxilizer 5000C. One other device that is coming along is made by the same company as the Intoxilizer, called an Intoxilizer 1400. It probably will be approved. It's designed to be a portable device. Has some advanced technology over the 5000C, but it has yet to be approved, and requires a little bit more time on its clock. One interesting development that Rick refers to in his paper, there is one device currently going through the approval process, the SL4, which has been requested to be approved both as a screening device and as an evidential instrument. And that's going to be a bit of a challenge for us to evaluate and approve. But it is an interesting development because as everything gets more computerized and smaller, it becomes quite practical to do that sort of thing. And we have to adjust our thinking to permit that.
We've mentioned the Intoxilizer 5000C. Jim, can you give us an explanation and demonstration of that?
Okay. This is the Intoxilizer 5000C with the keyboard. It's totally automatic and computerized. The detection of alcohol is accomplished by using infrared light. Alcohol will absorb certain wavelengths of infrared light. So basically the instrument using 3 wavelengths of infrared light measures the decrease in infrared light as there's alcohol in the sample. So if someone's blowing into the chamber, if there is alcohol in the breath, there'll be a greater and greater decrease of infrared light, which will be processed into a blood alcohol concentration. Now it is a new type of device with new detection. However, the same procedures still apply under the criminal code and also under our procedures. Number 1 is you have to do 2 subject tests and they have to be at least 15 minutes apart. That still applies even though we're using a new device. Number 2, it has to be checked using alcohol standard, and this will also be checked using an alcohol standard. Number 3 for our quality control is that the 2 results must be within 20 milligrams of each other, the truncated results. So basically, although it's a new device for detection, it's a nicer way of detecting alcohol. The same standards and criteria will apply. This Intoxilizer 5000C should be used in Metro Toronto. The first location in Canada should be in Metro Toronto the next month or so. At the Centre for Forensic Sciences, we've conducted 5 Intoxilizer 5000C training courses, and we now have about 60 Metro police officers who are also qualified as Intoxilizer 5000C operators. So you will see this, especially in Metro, in the next couple of months. And I think in the larger regional forces, you'll start to see them. Because basically for this type of device, it's about 4 times as fast as the breathalyzer, and will give you printed results. That's the main advantages. So if you have a location where there's a large number of tests, you may have some delays. With this device, you should be able to get rid of the backlog because you can do 4 subjects for the speed. You can do 1 for the breathalyzer. The good thing about it too is that basically the technician doesn't break open ampules or weigh things or gauge things. It's totally automatic. Basically the technician, what they do is they press the start test button. Okay, and I'm sure, I guess we haven't had a case on that, how you press the start test button legally with the index finger or the thumb or the forefinger, but we may have some case law on that in future, I guess. If we could have our subject up here again. Now, you never have this in real life because he's already passed the Alkyl test, so it wouldn't come in. So basically what we'll do is I'll start it. You just press the start test button. Okay, and basically there's certain messages that come on for the technician to see. The first flashing one says insert card. Okay, in Metro Toronto they'll have a card like this, similar in the field, where you can have both breath test results. The total output, the total printing of the test and everything will be given to the accused. So he'll have a copy of this. So it's basically like the breathalyzer check sheet, only the computer prints out all the different results. Okay, so the card is inserted, like so. Actually, if I can get you on the other side, I guess maybe it'd be easier to. Okay, the first thing, there's all sorts of prompts that depending on the police force, they'll request certain data to be put in as the person's name and the operator's name and other location be printed. The first one for this is the report number, which will be the card number. So the card number should match your printed report number. It beeps when it gets anxious on you, the instrument. If you spend a lot of time talking, it starts beeping at you to say, hurry up and do the test. So I just enter that, 003286, enter. Operator last name. Okay, my rank, sergeant, I guess, or inspector. Operator number. Okay, I'm just making up some of these things. My unit, obviously, is. Okay, subject last name.
Rose, R-O-S-E.
R-O-S-E. Okay, first name.
D is David.
David? Okay, initial.
S.
S. Okay, your gender. This is politically correct. It's gender rather than sex. Male. Okay, your license number.
31.
Okay, that's an indication of impairment. No, I'll just put some numbers on here. Okay, I'll just put some numbers. Doesn't matter for this case. Date of birth. Year.
61.
61. Month.
08.
08. And date. 12. Okay, your province is Ontario. Vehicle plate. Again, I'll just put some numbers. The arresting officer's last name also. Yeah, you don't have to tell him the last name. The arresting officer's rank and his number.
Just going to make it within a 2-hour limit.
The unit, yeah. That's true. The date of the occurrence. Okay. The time of the occurrence. The charge. Date of the arrest, time of the arrest. Demand, yes. Screening device, finally, no. Reviewed data, no. Okay, once we've entered all that, then we have the sequence coming into effect. You can hear a pump activated. It does everything automatically. So what it's doing right now is it's sucking in room air and is analyzing that room air to see if there's any interfering compound. If there is, the message you'll get will be ambient failed. It's not ambience like some police officers say. The ambience of the room is no good. It's the ambient of the room is no good. Okay, what it does then is do a flush, and it does 10 internal checks. There's 10 arrows that go across. It's checking the microprocessor stability of signal, drift, things like that. And then we're doing a calibration check. What's happening is the pump is activating. The air is recirculated through the sample chamber from the simulator. Now, the thing with the simulator is we will always get a result of 100. That's the target value. So there'll be no table of values, no room temperature, nothing like that. It will always be 100. And in this case, I think the result was 95. So the instrument is reading about 5 milligrams low. It then also does an air blank to clear the chamber of any the alcohol from the calibration chest. And the air blank is then recorded. All this information will be recorded down. It then does 10 internal checks again, checking temperature among 10 different things, processor, temperature, things like that. And finally, we come to please blow or /R into a mouthpiece. Okay, and we'll just use the mouthpiece. And if you just go over on this side now. Okay, if you can take a deep breath and blow until I tell you to stop. Okay? Blow harder, keep blowing, 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 keep blowing. That's fine. Okay, so his result should be less than 49 if the instruments are all correct. And his result is 29 milligrams. Okay, so that's obviously a pass. We then have a blank, which clears it, and it's all ready. Yes, you can go, yeah. Thank you for your assistance, although you should have had more beer. Oh, yes, you'll do the mouthwash, too. And lastly, all the results are printed. So all the data I entered about the name and that will be printed. Also the results of the blank test, the calibration check, the blank test, and the subject test will all be printed out. And what will happen is 15 minutes later, this procedure will be repeated, and the other side of the card will be inserted. In between, you can do another 3 subject tests because there's no ampules to change, no nothing. It's all ready to go again right away from the first test. And what will be happen too is the accused will be given a copy of this. So on the printer report will be the date, the time, location, device, the serial number, all the different tests that are done, so it'll have very, very good disclosure. And Metro, what they plan to do is have all the instruments tied into a central computer and be monitored that way. So there's all your data about the name, location, all the rest of that stuff. So there's no problem, again, with transcription errors where you're transcribing one to the other. It's all done computerized. Now, Rick wants me to do a mouth alcohol thing. This device, besides having different processing and different features, it has a mouth alcohol detector. And you can, which other devices don't have. It's another nice little feature to add. And it can detect actually mouth alcohol or alcohol in the mouth. And what I'm going to do is I'm going to stop entering all that data that I have to enter, because I don't want to do that again for all the tests. So there's just a little switch to pull. And I will volunteer myself for mouth alcohol. This mouthwash contains alcohol. I'm at a 0 blood alcohol concentration. You saw I passed on the screening device, so I'll just try some. I'll turn for those who are squeamish. Okay, so now what will happen is if I blow right away within about 10 minutes or so, I will get a falsely elevated breath alcohol concentration because of the alcohol is coming from the residual in the oral cavity. Now, the test procedure in the breathalyzer, 15 minutes for the first breath test, and proper duplication of the other 2 breath tests eliminates the mouth alcohol possibility. This one will not only have those 2 safeguards, but also the other safeguard of a slope detector, a mouth alcohol detector. And I'll start this again. Insert card. But again, I've turned all that preliminary data. Oops, I thought I turned it off. I got the wrong switch here. Report number is no error. 3. Yeah. There's no error. No, there's no error with this, but it's obviously with my stuff. Okay, what I'll do is rather than enter it all again, I'll change the other switch here. The police will not have access to the switching on this device because there's no reason for them to do it. No, it's true. Okay. Actually, it may have been better just to enter all that data in anyways, but okay. Okay, let's try it. Nope, it's not going to, it wants me to enter all the data in, okay? I'll just quickly go through it. Okay, now we're ready. Air blank again, the same procedure be followed. It still does the air blank going in, and then it'll do the 10 internal checks, and then it'll do the calibration check, which should be 100 plus or minus 10, and then it'll be ready for the subject test. No, I should be okay, I think. Okay, the advantage of the calibration check here is you see the sample is recirculated, so virtually there's no loss of alcohol when you're doing an alcohol standard test. It has an option, and again, it's totally automatic. Once the data has been entered, basically the person has just pressed the Start Test button. Now, after the calibration check, again, an air blank to clear it up. Basically, rather than having the handwritten breathalyzer test procedure, the results you'll get will be printed by the computer. The technician obviously will sign it and put different comments on it as required. Okay, 10 internal checks, and final say please blow. Okay, invalid sample, which indicates mouth alcohol. So the results will not be printed. If you could see the screen, what happens is with mouth alcohol, your level increases very rapidly, and then it drops off because as you're blowing fresh air from the lungs and clearing it, the levels drop off there dramatically. If there's no mouth alcohol, the slope is very similar, you get a plateau. So when the instrument detects this change, detects as mouth alcohol, and the result will be invalid sample. So you get no result of, say, invalid sample, so you'll have to wait your 15 minutes to do the second test, and by that time, mouth alcohol will have disappeared. Okay, the instrument's performing properly, just that I'm not performing properly on this.
Thank you. very much, Jim. We're running out of time, and I'd like to conclude our session by asking Jerry and Steve if there's some practical pointers they can think of for when the intoxilizer hits the streets and you're now contacted by a client who's blown not into a breathalyzer but into the intoxilizer.
I think the issues are still going to be the same as on the breathalyzer. You may have some less luck with some judge's perception of the new machine. As soon as practical, it might become an issue depending on the operator's ability to deal with the keyboard. But Carter, I think, until we get your decision at Gilbert, would still be a live issue. The alcohol standard, obtaining samples of the alcohol standard, I think, would still be a live issue. Perhaps the operator error, like the transcribing error, is eliminated. The issue of your client wanting to see the breathalyzer readings might be eliminated by the fact that it's no longer a he's going to get the printout anyway, and there is some evidence of what the reading was. But for the most part, I would think that the issues are going to be very similar to the breathalyzer.
Jerry?
I would agree. I don't think that anything essentially changes. I think the issues of evidence to the contrary are still there because it's a device that certainly is more sophisticated than, well, I wouldn't like to say more sophisticated, that's a relative term, but certainly it has more options and more ability to control functions. But on the other hand, by removing operator intervention, you're also putting things into the background that you're not aware of by the computer control. And we have seen the inflexibility of the microprocessor just by the little example we had with Jim just a minute ago, that it has a mind of its own and it will function in that regard. The other issue that I think is important with respect to that device is the same one I raised with the Alcates 7410. I think you'll have more refusals, because now you look again, we have a third parameter that's being measured in this device. We not only have pressure and time, but we now have the slope of the breath curve as the sample is being taken. And there has to be a certain value achieved with that slope. In other words, the slope shouldn't be changing, should be zero. It's looking for the alveolar plateau where the alcohol content is no longer changing. And my understanding in the software, there's a feature that measures the change in the slope, and unless that's achieved, sample will not be taken or will not be reported. So I think you'll see more refusals again in this particular aspect. I think that there are comments like, for example, this device, if you have a subject, you're doing 6 blank tests, 40 internal checks, 2 calibration standard tests, 2 subject tests, and that might tend to suggest, well, gee, this thing's perfect. But I would like to remind all of you that if there's an error anywhere externally or internally, no matter how many times you do it, you repeat the error. And so those can be difficulties, although they should be minimized with this kind of technology.
Thank you, Jerry. We have a few minutes left if there are any questions from the floor for the panelists.
The screening device, the Alkyl, you say calibration. Can you explain that, and does it have to be contemporaneous with each use of the screening device?
I don't know if everyone heard that, Jim. The question is about the calibration of the screening device. Could you perhaps repeat the question?
Yes, I was asking about the calibration of the screening device. Is the calibration done at the same time as you do a subject test? And no, the calibration standards currently are that the screening device be checked once a week, and they would be using the simulator, blowing into it, and you should get 100 as your result. And they'll calibrate it to 100 every. The Alkyl test 7410, the fuel cell is very stable, and the manufacturer says 6 months. Some jurisdictions does a calibration every 3 months. So no, the calibration is done currently in Ontario once a week.
Can I make a comment in that regard too? Sure. I think that there are certain specifications now that really the Alcohol Test Committee, in theory, could do away with because of the software control on these devices. But I'm glad to see that they're not going to be done away with because they give a second level of quality assurance, like this business of waiting 15 minutes before a sample is taken. Even though this device can detect, say, mouth alcohol, it's good that those assurances will still be there, that they will wait 15 minutes before a sample is taken, or that calibration of these devices will be done on a weekly basis. So those are elements of quality assurance that will help to reinforce the sophisticated technology. So I think that those specifications should stay there.
Go ahead.
I've written literally dozens of letters asking this question. It's never been answered. Assuming that the Solicitor General's Department was aware only after August 23rd, 24th, 1992 that there were serious problems, the Crown's office had to be notified sometime after. Why wasn't the Lieutenant's Constable? It's actually for you, Rick.
I thought I'd look at Doug. Well, I suppose the answer to that, I know Marc earlier today was commenting about imputing knowledge to police officers and that focusing down to them or filtering down to them about their knowledge about the approved screening device and the modifications that had been made. And I would suggest to you that I think the same type of analogy can be made. There is we've talked a little bit about the approval process. The alert instrument remains an approved instrument. There is a statement that I think most people are familiar with that goes out in March of 1993 by the Alcohol Tests Committee. It's a public statement indicating that there is a concern with the recent unauthorized modifications to the machine. So you may disagree with me, Bobby, but I think that although there certainly were earlier issues in respect of the alert, at least dealing with the latest area that ultimately led to the recall, I, for one, don't really see how there can be an argument or at least knowledge imputed to Crown attorneys that there was some type of difficulty with the machine that Crown's knew about. The first that there seemed to be a real public concern made went back to the statement of the Alcohol Tests Committee in March. The statement speaks for itself, and within 4 weeks of the statement being issued in April of 1993, the machine was recalled. So if your question really deals with what happened before that, I suppose it's really a matter of the type of modifications that were made and whether there was substance to them. They're not matters, I think, of public. They're not matters, rather, of private information. They're all well documented, and I appreciate that these are some of the issues that are being argued in the courts, but I think really the only reply that I can make is that the Alcohol Tests Committee issued a statement in March of 1993 indicating that they had concerns. They had brought them to the attention of the Department of Justice, and then in April, I believe April 22nd of 1993, the machine was recalled from service. That's the perspective I have. I appreciate it may not be one shared by other people, and you may well be getting, in fact, different answers to that jurisdictions, and it'll have to work its way through the courts.
I'm getting stonewalled, just telling me they won't answer. I've never got the reply. You know, Alan Gold's letter, I always add on a little bit about saying, I want to know when you were aware and why I wasn't aware, and Alan's stingy. No one's ever answered.
Well, one thing I can say in the material itself, and I believe in the Lawyer's News Magazine article that was just out the other week ago, there's quite a litany in terms of the documentation, and I think you'll see those dates referred to of March and April of 1993. Keith?
Are the alert officers told to ask every person whether they either been smoking or used mouthwash so they know whether they should wait for 15 minutes? And secondly, how does that tie in with the requirement to be taken forthwith? It seems that the manufacturer is putting out requirements which are inconsistent with what the criminal code says the thing must be, how it must be used.
Well, I think that question will refer to Doug Lucas, but on the second part of it, in David Fairgrieve's judgment in Richard, that was the one of the issues that he dealt with, and that he agreed that if it was a manufacturer's policy, that was all well and good, but the Supreme Court in Grant had spoken, and they had indicated what forthwith meant. Now, that's one interpretation. The Court of Appeal will eventually be getting that. On the other hand, Judge MacDonnell and Plautus which is a 1992 judgment, again after Grant thought that it was reasonable to wait if there was residual alcohol. In the first part of your question, though, you asked about where that was coming from. Doug, could you deal with
yes.
that?
They are told that, yeah. And it has nothing, and the second part is really not so much the manufacturer's instructions, it's just simply the science of it all. If you have most alcohol there, it can give you a false reading for up to 15 minutes, therefore you can't do a proper reading or a proper analysis. And one interpretation of forthwith, in the way the demand is written, is forthwith to do a proper analysis, and you can't do a proper analysis until there hasn't been any alcohol there in the mouth for 15 minutes.
Keith, I mentioned Burnshaw earlier today, the British Columbia Court of Appeal case. It's an interesting judgment because they had been asked to overrule Gartrell, which is one of the 15-minute periods of waiting. And although they didn't deal with the issue, they did make the comment that were the officer not to have waited, knowing that there was the presence of residual alcohol in the accused's mouth, they would have been depriving themselves of reasonable grounds to make the breathalyzer demand. Because they would have known that the alert result wouldn't have been a reliable one. So there's, I think, that part of the argument too.
There's general division cases going both ways, and Plautus, for one, was upheld, unfortunately. That's mine.
I promised I wouldn't mention it.
Right.
Go ahead.
No, it depends on how hard you blow.
One of the example samples we saw here, if you remember, was Hugh and Mr. Rose, seemed to take about 10 seconds. And,
I don't know. Again, it depends on the volume which you can take. The sample could be taken as short as 4 to 5 seconds, or as long as 12 seconds, depending on how hard the person blows. The device always takes a sample of 1.2 liters of breath. Once 1.2 liters of breath has been vented out, then it'll collect the sample.
but the alert, the sort of J3A seemed to take something like
It was 5 seconds no matter what.
okay. So now you can have a situation where a lot of people out there who have any kind of breathing problem, lung problem, cold, asthma, are going to have difficulty going 10 seconds.
No.
Let's say you've got somebody who is going to say legitimately,
A short elderly female? Yes. Okay, I would agree. Yeah.
I've talked to Rick about this before, that they can't blow, so they please go back to the police station and blow in a real machine. They want to show you they don't have overrated. So it's going to be a policy decision that's going to assist them in doing that, because the present decision is they won't be allowed to do it, they'll charge and refuse no matter how much they want to take.
I'd ask Doug if he's the senior on that.
I think it's a hypothetical question, really. We don't really see that there's going to be any difference in the time in the sampling. It's just that if you don't blow very hard, you can blow longer, and that's just the way it is. If you blow very hard, you blow shorter. In fact, it may be easier with the Alcates, because if you blow really hard on the alert, you'd still have to blow for 5 seconds, whereas you might only have to blow for 4 on the Alcates. So
Let's deal with the issue that the person who's nervous or upset, they blow as hard as they can. And I'm just dealing with then the separate issue of policy. When somebody says that I'm having trouble with this machine for whatever reason, and I have a chance to blow in a real machine and prove to you that I'm not overrated. Has that been discussed at all? Is this
no, it hasn't.
Steve, any thoughts on that?
somewhere every day?
From the court standpoint, I think that Danny's right that there would be a charge of refuse, and it'd probably be upheld as the law stands right now, because the courts come to they'll let you have as many chances at the roadside, but once you're defeating the purpose of the roadside by having going to the station, the charge has been upheld.
In fact, if you look at the section in question, I think on a strict interpretation that's correct. There's one offense of refusal. It applies to either form of demand, and in fact, to vary your example somewhat, you in theory, I think, could have the accused indicating a willingness to blow into the machine but refusing to accompany the officer to his or her motor vehicle, and our Court of Appeal has indicated that they're really separate items, and the refusal to accompany the officer would be sufficient for the refusal offense. We're a little bit over our time now. The instruments will be available at the front to come up and take a look at and speak to the panelists on. I'd like to thank you very much for your patience.